Lawful money. What is lawful money? Let's just get that gray area out of the way. A lot of people create contracts privately or put documents into public courts or do other things, whatever it is people do these days. And they use this buzzword, lawful money. And they make reference to Article 1, Section 10 of the United States Constitution. So let's read it. No state shall enter into, of course, the word lawful money is used in other documents that preceded this, that this was founded upon. But this is the specific part that people milk. So let's just really comprehend what that means and whether people's perspective of it is flawed or not, and whether their demand for performance based on their perception and their use to this reference is proper or not. I'm not saying it's right, it's wrong. We're just laying it all out. You come to your conclusion at the end. It says no state shall enter into any treaty, alliance, or confederation, usurpation against the United States, grant letter of marque and reprisal, coin money, emit bill of credit, make anything but gold and silver a tender in payment of debt. This is the specific part that people utilize this clause. Make anything but gold and silver coins a tender in payment of debt. And then goes on to say pass any bill of attainder ex post facto law or laws impairing the obligation of contract or grant any title of nobility. Within this first part, there were several clauses. And each and every one of these clauses complement or leaves a way out for this clause that says no state shall enter into. That says no state shall make anything but gold and silver coin a tender in payment of debt. So now you're creating contract and saying, whether you realize it's a contract or not, you're saying this is due based on lawful money, and I can only accept this based on lawful money. But then right after that, it says no state shall enter laws impairing the obligations of contract. Meaning now that you've proposed it according to this gold and silver, someone has to accept that contract. So now if you're trying to impose it on them and saying this is the only thing that exists, now you are impairing the obligation of contract. Because usually your supposition of what makes someone liable to perform against that contract that you're claiming money, lawful money based on Section 10, Article 1, that claim has no standing because you cannot prove it. And because you cannot prove it, you cannot hold anyone liable. Now, this specific part where it talks about no state shall enter into a treaty or alliance, when you really look at what a state means, it really means any social political body, any corporate entity, whether it's the one that you create or the specific ones that is to be limited, that have their grant of power from the Constitution, the state of, the city of, the town of, the borough of, so on and so forth. Now that's the other party within that bilateral contract. Now really there are many, many more parties involved in this Constitution. For you to really know what this thing really means that everybody milks, Article 1, Section 10, you have to know who the parties were that were involved in this Constitution. There were different empires involved. This specific thing was directed to subject of Great Britain that came here to North America to do commerce. Now, who was behind all this? Sorry to break your bubble, but all those founding fathers people going about, those were not the people in power. Because if they were really in power, North America would not be the way and the condition that it's in right now. But that's another subject for another day. The one who proposed grant of this thing and the one who structured it were the monarchs and the royals in the Americas, who used this specific tool as a foundation to permit certain activities. And upon such permission, they limited those activities, commercial. And the state that they were referring to are the different subdivisions, aka colonies, of Great Britain that came here to do business. Prussia Prussa, was one of those monarchs that had jurisdiction here in North America. You hear people talk about many different things, but there are different parties that had power to make such stipulation. But just because they created this contract called the Constitution between themselves to prevent war and feud does not mean you can't use it. But in order for you to use it, you must comprehend that foundational principle first before you go on about because you saw some PDF and someone said something and you're running away with it. That is the root of the problem of many people today who are creating all these different contracts, making reference to Article 1, Section 10, lawful money. They don't even know who created it and who it's for, and why those Bill of Rights specifically exist. If you read the intent behind the Declaration of Independence, go to the Library of Congress, read the intent behind it. There are many, even if you don't do that, there are many PDFs out here that will show you footnotes that will tell you the intent behind the difference between the Bill of Rights and all the other articles and who it applies to. But that still doesn't mean you can't use it. So now if you're making reference to Article 1, Section 10 regarding lawful money, and you're demanding somebody and you're saying you got to do this based on lawful money. Say you're coming with your own state, meaning you're not an ens legis. You do properly, you have interfaced and you have introduced evidence that's saying, okay, I am my own state and I have my own social political body and I'm then doing this. That gives me the standing to speak with you as a state. Cool, you did that. All right. And now you're making a demand, but the claim is another thing. Can that claim be substantiated? That's 2 right there. 3, if you're telling them the only thing that they can do to satisfy the liability, and the other party, aka them that you're making reference to, is a subsidiary, enclaves, or an extension of the United States, and you're telling them the only thing that they are obligated to do and the only way that they can satisfy the liability is coin and silver, because the Constitution mandates that no state shall make anything but gold and silver in tender of payment. Okay. But then you also fail to realize that it said no state shall coin money, emit bill of credit. So if they lack the ability to coin money as the United States, why then are you demanding silver and coin? Because you have to realize the people who structured this use these specific words so that they can stay in power. Those monarchs, they wanted to stay in power. That's why they structured this way. And if you don't know the foundational history behind it, you will just be throwing all these words out here thinking you're doing something. The other party, on the other hand, who are extension of the United States, will look at this and go, okay, all right, you keep sending those papers. We'll keep throwing them in the trash. What proof do you have that you have the power to make this demand? What proof do you have that they have the power to give you those gold and silver? And if somehow there are subsequent laws in harmony with this that does allow them to coin money, because they do, they still coin silvers, although it has a lot of zinc and all this other stuff in it, but they still nonetheless coin natural resource. The U.S. Mint, different ones in Philadelphia, all these, and when you look at the mark on any coins, you will see P or D. That's the logo for the location where it was coined, where the mint was. But those mints and those coins are the properties of the United States. So now you have someone copyrighted property and trademark interest. You want to spend and you're demanding them to give you their money with their face on it. Do you see the flaw behind you demanding gold and silver? Because that's vague. If you're not demanding specific types of gold and silver, then your contract is flawed automatically right there. And then you yourself are impairing the obligation of contracts, because most of the things that people do when they demand lawful money according to Article 1, Section 10 is a unilateral contract. because the majority of claim within those suppositions cannot be substantiated. It just can't. Now let's go to the Federal Reserve website. Ask, what is lawful money? Remember, Federal Reserve is the international agency that contracts with other enclaves of the British Empire here in North America. And they engage in their commerce. Lawful money is a term. And now this is a term used in Federal Reserve Act. Oh. So the United States Constitution doesn't even mention anything about lawful money. You're the one that's mixing and matching. The United States Constitution clearly tells you no state shall make anything but gold or silver coin a tender of payment in debt. That's it. But now you're taking a terminology from the Federal Reserve Act. These people that you don't like, that you're saying they're the fraudsters and all that. We're not saying they're right or wrong, but people do make that claim. We're not saying it's correct or incorrect. But these same people that you're supposedly wanting to free yourself from, they have an act that governs their activities. And that term, quote unquote, lawful money that everybody throws around is a terminology within their own rules and regulation of their activities. Now you're mixing and matching that with positive law, which is the Constitution. And somehow you're hoping some magic is going to happen and somebody's going to be afraid and want to act upon that supposition of contract that you're demanding. Reality does not function that way. Someone has misled you. It seems this has to be repeated over and over and over to people for them to actually really get it. The hype train is not what it is. It's not all that. Read. Stop for a moment. Look at the words. We don't even have to go further from here to see the flaw in a lot of people making demands of lawful money based on Article 1, Section 10. We don't even have to go into the Federal Reserve Act because everything speaks for itself at this point. Then goes on to say the act that authorizes the Board of Governors, aka the Federal Reserve Act, of the Federal Reserve System. And then it's a link and chain of different entities that work together to issue a Federal Reserve note, their private property. So now you're using a term from their act to regulate their private property, which is Federal Reserve note. And automatically, you yourself don't realize you just impaired the laws governing obligation of contract. You yourself just violated the same section that you're supposedly using to back up your claim. Don't you see? And then the same breath, you also will say that Federal Reserve note is a bill. They own it. It's not yours. Yet here you are using terminology from the act that governed that thing that you say is not yours, but somehow you're trying to mix and match it with a positive law. What don't you get? It goes on to say the act states that Federal Reserve notes. Listen to this. The act states that Federal Reserve notes, in quotes, shall be obligations of the United States. Federal Reserve notes shall be obligations. Now, this is not the verbiage of the Constitution. This is the Federal Reserve Act governing their private properties and their creation. And it's saying this creation shall be the obligation of the United States. The Federal Reserve note is their private property that they've created based on the rights and obligations of contract. Are you seeing how Federal Reserve notes are lawful now? Because they created it. Amongst themselves, to be used by themselves and their extension, enclaves, and subsidiaries. within their commercial affairs that was sanctioned by the Constitution. Now, based on the laws of contract, which anyone shall not impair, specifically the state, aka United States, and any other social political body with any commercial interest. According to the Constitution, the law of contract that's affirmed that nobody shall impair, they created Federal Reserve Act based on contract, that this is our currency that we will have amongst us. Now, whether you choose to join them knowingly or unknowingly and you use that same contract note, it's your problem. They don't care. They know what they're doing. And if you join them in their cause, cool, no problem. But if you join it and you don't know how to finagle it and get it to work for you, and you just hate in the Federal Reserve notes, cool, no problem. They're still getting done what they're doing. They're still accomplishing their mission. So within this contract called the Federal Reserve Act, FUBU, for us by us, it says on that this private note based on contract among us shall be the obligations of the United States, and shall be receivable by all national and member banks and Federal Reserve banks, and for all taxes, customs, and other public dues. It shall be receivable, meaning we are going to honor this within all our subsidiary entities that we've used as banking system. See this term, obligations of the United States? They shall be redeemed in lawful money on demand at the Treasury Department of the United States. So all of you doing promissory notes, is it in accordance to the Federal Reserve Act? And are you a signatory to the Federal Reserve Act? Because all you doing these promissory notes, talking about going to the Treasury window, doing this and that, redeeming for lawful money. Have you read the Federal Reserve Act? Those are the questions you ought to ask yourself. They shall be redeemed in lawful money on demand of the Treasury Department of the United States in the city of Washington. Now remember, it's referring to Federal Reserve notes now. Nothing else. They will honor it at the Treasury Department of the United States, located at Washington, District of Columbia, or at the Federal Reserve Bank. That's the quote. It then goes and say the act did not, however, define the term lawful money. But up until 1913, which was the year that Federal Reserve Act was enacted, by the way, the only currency used by the United States was legally recognized as lawful money was various issues of demand notes, subsequently known as old demand notes, and United States notes authorized by Congress during the Civil War. So it's telling you that lawful money, contrary to your presumption, is really not just gold and silver. It could be, based on the laws of contract. If the other party agrees to it, sure. And they've created their law of contract among themselves based on the foundation that the Constitution has authorized them to create their own instrument, to use among themselves, to perpetuate their own commerce. Because whoever controls the money controls lifestyle. And then it goes beyond whoever controls the money, whose money is in it. And then there's way more incorporeal things that you don't see, whereby if a seal is on the money, it's affecting the flow of life of everything perpetually. Whoever's face is on it, whatever words on it, it is affecting how that money is handled. It is affecting how that money flows, and ultimately who is going to benefit. So it goes beyond just pen and paper. So when you use that word lawful money, stop for a moment and think about it. When you make and demand that somebody compensate you or pay you something, is your claim valid? Are you coming in the proper capacity? And also, in the process of you doing that, are you yourself breaking the laws, the foundational law, the Constitution that you are making reference to? And in the process of all that, if you've yet to ask yourself that question and affirmatively confirmed, then you are one thing and one thing only, a victim. Don't be a victim. The one thing they don't tell you is the amount of people that are being locked up for doing all these lawful demand, all these other things like promissory note, all these other things like condition acceptance and court cases and lawful, all these stuff. You don't hear that, but you see videos of people going on and on about lawful money, Article 1, Section 10. When in truth, they're not even using that clause right because they don't even understand the foundation and what is lawful money itself. And then there's this other word called legal tender. Let's read it. Remember, all this is admissible evidence. This is an official publication from an official website, Federal Reserve, their gov. So, believe it or not, for those of you who you don't promissory notes, you might want to just keep this for your record in case something comes back at you. Or for those of you who are already experiencing it, but don't want to come out and talk because you know no one is going to help you, you should probably put this into consideration, because solution, if you listen to this closely, the solution is also herein. It goes on to say, at the time, the Civil War, some currency was not considered legal tender. This is another subject matter now. Even though lawful and legal can be correlated, but listen to this. Although it could be used by National Banking Association as lawful money reserve, legal tender. It then goes on to say, at the time, Civil War, some currency was not considered legal tender, meaning something that's permitted by law to circulate. Although it could be used by National Banking Association as lawful money reserve. This is the quote from the Federal Reserve Act. Thus, the term, quote unquote, lawful money had a broader meaning than the term legal tender. At the time, some currency, meaning there were other types of currency being used. So tell me, if there's a group of people that came to the North America, South Central America, and they were doing business and they created, based on laws of contract, certain things to regulate themselves and to regulate commerce. And a certain group of people was overseeing them that created a positive law called the Constitution to limit and to oversee those commercial activities. And those people who came here for commerce created something to be used for themselves under the supervision of others. What were those other people using prior to those people coming in here to do that commerce? That's the question you ought to ask yourself. You want to create currencies and notes and stuff like that to have weight and to make someone demand something? You have to know that everything is about contract. And when it comes to lawful money and all that you're making demands against them, they're not going to listen to you for a very good reason, a viable reason at that. Some currency was not considered legal tender, meaning they're not obligated to recognize it based on the limitation of their act, based on the rights and obligation of contract, meaning they were not meant to interface with certain people in the first place. Although it could be used by National Banking Association as lawful money reserve, meaning we can put it as a backup for what we're doing in case we need to interface with these people. But amongst ourselves, we're going to be using the Federal Reserve notes. Thus, the term lawful money had a broader meaning than the term legal tender. Are you getting it? In 1933, everybody knows about the bankruptcy. Everybody milks the bankruptcy. Okay, bankruptcy occurred. Now what? How does that validate you? Oh, well, there's no more lawful money, so we can just discharge everything. Okay, but there's still rights and obligation of contract that still stands. And then that takes you back to a full circle. Congress changed the law. Remember, the Constitution is always telling you about what Congress does, what Congress doesn't do, what Congress can do, what Congress cannot do. In 1933, Congress changed the law so that all U.S. coins and currency, including Federal Reserve notes, aka lawful money based on rights and obligation of contract among people who are party to use the Federal Reserve notes, regardless of when issued, constitute legal tender for all purposes. Remember, lawful money has a broad definition. Legal tender is more specific. Federal and state courts since then have repeatedly held that Federal Reserve notes are also lawful money. Res judicata. So to all of you always talking about common law is also judge-made law, judge-made law is common law. Okay, go ahead and challenge this. If you want to keep making demands for lawful money under the supposition it's just coin and silver, go ahead and do something about this case law. Because if you go deep into this case law, you start to see, even though there were some loopholes, it actually kind of sort of makes sense because of the right to contract. It doesn't have to be complex. It really is that simple. If you are creating your contract and you're demanding somebody make a payment based on a superseding contract that you don't even have a standing in and you are not designed and meant to be a part of, then what in the world are you even doing in the first instance? And if you do intend to make lawful demand for lawful money, at least know what it means. And if you choose to conditionally be a party to that, to use that as a medium of exchange, then create the contract in an appropriate manner that's in harmony with that. Then goes on to make reference to the case law. It is typical of the federal and state courts cases holding the Federal Reserve note as lawful money. In Millam, the United States Courts of Appeal, which makes final determination of how the law is interpreted, for the Ninth Circuit reviewed a judgment denying relief to an individual who sought to redeem $50 a $50 Federal Reserve Bank notes in lawful money, meaning he or she probably went up there to Washington and tried to redeem it because, you know, it's a promise to pay. There's no money out here. There's no money out here. There's no money. Right? So I'm just going to go redeem it. The United States tendered Millam $50 in Federal Reserve notes, but Millam refused the notes, asserting that lawful money must be gold or silver. The Ninth Circuit, noting that this matter has been put to rest by the U.S. Supreme Court nearly a century before the legal tender case, Juilliard versus Grimman, rejected the assertion as frivolous and affirmed the judgment. Meaning, if you go to the window, the Federal Reserve window, and you give them a 50 bill, you give them a 50 bill, right? You say, give me coin and silver. Where in the Constitution does it say that coins and silver is the only thing that serves as lawful money? It tells you that gold and silver is the only thing that you would tender as payment of debt. And no one is arguing otherwise that Federal Reserve note are not debt instrument. No one is saying any of that. But one, are you a party to the Federal Reserve Act? Because if you're a party to the Federal Reserve Act, you're automatically making yourself a debtor. And everybody wants to claim and say that they're not debtors, they're creditors. So if you're saying you're going to go to the Federal Reserve Act and redeem some money, you are making yourself a debtor. Why? Because Article 6 talks about debts. All debts contracted in engagement entered into before an adoption of this Constitution shall be valid shall be as valid against the United States under this Constitution as under the Confederation. Meaning there were other bodies of instrument before this Constitution that dealt with who the creditor was and who the debtor was. And the United States, right from the start, were always the debtor. So now you, the one who's saying that you're the creditor, you're going to the debtor saying, give me money. I thought the debtor wasn't supposed to have money. But let's just say you're studying enough and you're trying to subrogate, right? Is the contract valid to do that subrogation? And why are you using that Federal Reserve note if you're not a party to the Federal Reserve Act? You're saying you're not a United States citizen, right? Oh, so then that means you're not supposed to be using Federal Reserve note. But let's just say, even at best, you know how to enter into contracts. You've done everything right, and you still took that up there and made that demand. They're going to tell you that gold and coin and silver, after the Civil War, we cannot distribute it. And if you want that, you have to independently get it from yourself, for yourself. So go ahead and get you some monster boxes and then engage in private contracts with people from international communities. The least you can't say is that someone hasn't told you. Evolve. Evolve. Get past presumptions and mental jack-offs that you've heard from some people who mix and match things and mislead you because it sounds good. They make reference to something that sounds good, but they then break it down to you. Stop allowing people to lie to you, and you yourself stop lying to yourself. Be truthful. Begin by being truthful. And then doors would open. Solutions exist. But get away from belligerent mode. Wash your brain off of all whatever that trash people have put in you. Because that stuff either gets you stuck in a circle, or gets you stuck in one position, or pulls you back. Best of luck.